very pleased to introduce Brian Kane, who will be telling us some basics about the Idaho Open Meeting Law. Brian received his Bachelor of Arts degree in History and Political Science from the University of Idaho. He earned his law degree from Northwestern School of Law at Lewis and Clark College in Portland, Oregon. He was admitted to the Idaho State Bar in 2000 and began his practice in the private sector. Brian has been with the Attorney General's office since 2001 and currently serves as Assistant Chief Deputy Attorney General. In this role, he serves as legal counsel to the Secretary of State, the legislature, other elected officials, and acts as a liaison between the Attorney General and local, state, and federal governments. He has argued before the Idaho Supreme Court and the Ninth Circuit Court of Appeals. Brian is an avid runner who recently completed the Chicago Marathon, and he is a veteran of the 1st Cavalry Division of the U.S. Army. He and his wife Emily have been married for 12 years and have 2 children, and I'd like you to please welcome Brian Kane.
Thank you. Give me a second here to get us fired up.
I'm always fired up. Woohoo! Woohoo! Get some life going on here.
All right, we're live.
Can we turn off that area?
So I'm here tonight to walk you through Idaho's open meeting law. And first off, I want to thank everyone that commented on my tie. Probably is no surprise to you, but I wear this back down in Boise. It doesn't seem to ever get noticed. I think that folks are colorblind to this color scheme. I think the neon colors have affected their vision.
Orange.
You know, all that hunter safety gear they wear.
Yes.
I'm here tonight to discuss the Idaho open meeting law. And I think that, you know, as I look at the open meeting law, you know, statutes serve several different purposes. And the open meeting law is one of those statutes that I think when the legislature adopted it, they adopted it with the goal of compliance, meaning they want to encourage folks to conduct open meetings, and they've created a mechanism by which it gives kind of step-by-step instructions. The penalties, there are penalties associated with not following them, but as you go through it, the whole goal is compliance. And so when you look at the open meeting law, you kind of start from that general compliance point. It starts out with the policy of the state is that the formation of public policy is public business and shall not be conducted in secret. That's an important starting point because to me that goes back to the Attorney General's point about government being a trusteeship, meaning we act for the benefit of all those citizens that we represent. That resonates within this public policy because if you come at the open meeting law with the perspective of how do I get around the open meeting law, how do I avoid its application, can I find a loophole, then you've kind of failed in that initial trusteeship that's been given to you as an elected representative or a public official. As an attorney, I'll be the first person to tell you the law has loopholes. If you want to find them, you absolutely can find them. But as a public official, I think that you're kind of failing in your most basic public duty if that's your approach. Tonight, as we go through this, the presentation's been broken down into 5 parts, and I will make a deal with you. If you stick with me through parts 1 through 4, you should have nothing to worry about on part 5, which is, I mean, that's good news, right? And I think that that's pretty fair. We're going to go through definitions, the notice and agenda, the conduct of the meeting, executive sessions, and enforcement. One other thing that is always worth pointing out, since we're going to be working with statutes, and that is rules of statutory construction. And perhaps the most important rule of statutory construction that I can give you is that if the legislature creates a definition of a term, and it contradicts perhaps Webster's or your own logic and reason, for example, if it quacks, has feathers, waddles, and it's a dog, then that's our definition of a dog, no matter what we think or what we bring to the table. So always keep that in mind when you're looking at definitions and thinking, that doesn't exactly square up with what I think of that. The first two initial definitions are where kind of the open meeting law really starts. The first is decision, and that's any determination, action, vote, or final disposition upon a motion, proposal, resolution, order, on which a vote of a governing body is required at any meeting at which a quorum is present. That seems like a pretty narrow definition, meaning we're only talking about these decision points, we're only talking about when there's a quorum and when we take a vote. That seems fairly narrow. The key, though, is this second decision, and that's the definition. And the second definition is of deliberation, which is the receipt or exchange of information or opinion relating to a decision. To me, the real key here is if you are on the road to a decision with your discussions, then it should be conducted within an open meeting. And so if you can see the decision on the horizon and you're in those discussions, that's a good indicator that it should be done in an open meeting. That also, the fact that we've got a definition of deliberation means that when you're making decisions, there probably should be discussion prior to the decision. We've had some examples where folks have called our office and made complaints and said, we go to the council meeting and they never have any discussion on any of their motions. They just vote and everything's done. That's a red flag. We had one governing body over in the eastern part of the state that actually had a brag point of having the shortest meetings in the state because they didn't do any discussion. But what does that do for confidence within the system? And what is the default answer for why they're not having discussion? The default is it's because you've already prearranged all of your votes. That's a problem. Public agency, I'm not going to go through the definition of public agency. Essentially, if you're in government, you're a public agency. I am going to, however, turn your attention to this last sentence here. Any sub-agency of a public agency created by or pursuant to statute, ordinance, or other legislative act. We get a lot of questions about subcommittees and work groups and task forces and all the other different variations of things that folks create. If that group is going to make a recommendation to the board for a decision, meaning you're part of that road to the decision, then you should fall under the open meeting law. And so you can't create a subcommittee to avoid application of the open meeting law. A governing body is simply the members of a public agency consisting of 2 or more members with the authority to make decisions. That means that once you get beyond any entity that's headed by a single person, any type of board or commission, regardless of size, they fall under the open meetings law. And then a meeting.
I don't fall under the open meeting law. Because I'm not a board, I'm a single individual. So as the Attorney General, if I want to meet with myself, I don't have to give notice of an open meeting.
It does, however, draw attention when he decides he is going to meet with himself. A meeting is simply the convening of a governing body or a public agency to make a decision or to deliberate toward a decision on any matter. One of the things that we always get questions about are with quorums. And so you heard the Attorney General refer to it earlier where he said, can we get in a car and drive across town to go to a funeral? Is the fact that that group got together and had breakfast a violation of the open meeting law in and of itself? And the answer is no. It's not until they start talking about the county business that it becomes a violation of the open meeting law. I will give you a cautionary note on getting together with fellow city council members, school board members, commissioners, whatever it is. And then the cautionary note is this. In any group, you're kind of bound by what it is that you have in common. And so, for example, we're in the holiday season right now. I'll go to a bunch of little holiday parties, and there'll be other attorneys in the room. I will naturally gravitate towards the other attorneys in the room because apparently we're the only people that can stand one another. And our conversation actually follows a very predictable arc. And of course, the fact that it's so predictable might be why I don't have more friends. But we'll talk about kind of our kids, vacations, movies. So you go through this kind of standard small talk progress, And you always hit a point where there's that kind of awkward pause. You're kind of looking at each other and you're saying, "Oh, maybe I should freshen my drink or get something to eat." Or you keep talking, and what invariably do you start talking about? Work, cases. What are you working on? What's interesting that's happened? The same phenomenon applies within the context of a group of county commissioners or city councilmen or anything. And so absolutely you can get together. The real question isn't not whether or not you can get together. The real question is, do you have the self-discipline to recognize I'm about to start talking about things I shouldn't start talking about and walk away? So that's the real test point. There are two types of meetings. There are regular and special meetings. A regular meeting requires 5 calendar day meeting notice and a 48-hour agenda notice. If you are an entity that meets regularly, say you meet the second Tuesday of every month, you can publish a schedule of all those meetings and then just post your 48-hour agenda notice. Special meetings shall have to have at least 24-hour notice unless an emergency exists. One other thing with special meetings and notice is that the secretary or clerk of the board should maintain a list of media who want to receive notice of special meetings. And then once you schedule a special meeting, the clerk actually has a responsibility to notify all of the folks on that list of the special meeting. Oops, wrong button. Executive sessions, you can have a meeting with only an executive session as its purpose. You have to give at least a 24-hour meeting and agenda notice, and the notice has to state the reason and specific provision of law authorizing the session. When you post the notice, the law requires that the notice be posted in a prominent place at the principal office of the public agency. If it's an entity that doesn't have a public office or a principal office, then it goes where the building where the meeting's held. The real key there is got to be prominent. You can't have it buried under a stack of papers. You can't stick it, underneath 4 different Vandal sports posters, saying when the meeting's going to be. Prominent means front and center.
But Brian, I put it on the internet, so everybody knows where it is.
Yes, Mr. Attorney General, the internet is a great spot to post your meeting notice, but under the law, you still have to post it according to what the law requires. And so the internet is great because aspirationally it's above and beyond what the law requires, but don't forget about that basic legal requirement under the Open Meetings Law. The notice should have, the agenda, should have all items of probable discussion. Believe it or not, we've given, I think, around number 30 or 31 of these presentations, and we still get agendas into our office from folks complaining where it says, city council meeting, old business, new business, adjourn. And that's it. If that is what your agenda looks like, please fix it. All items of probable discussion. That means you should have anything that you plan on taking a vote on. A lot of times you'll have informational items that somebody's going to come and tell you about. The other thing is that you're allowed to amend your agenda. And so the way that agenda amendments work is there are 3 circumstances. If it's outside of 48 hours, you just post your new agenda because under the law you have to have 48-hour agenda notice. If it's within that 48 hours, but more than 24 hours outside of it, you post an amended agenda and then adopt the amended agenda at the start of your meeting. Again, you want to provide as much notice to folks. This has changed since the first time we posted it. And then if you get inside of that 24-hour period, you can amend the agenda within the meeting. You make a motion to amend the agenda, state a good faith reason for why the amendment is being made or offered, and then have a vote. And if folks vote yes, you can amend the agenda, then it's amended. And if they, for whatever reason, say we're not going to amend it, then that's the end of it. All meetings are shall be open to the public, and you can't hold a meeting any place where there's discrimination for a variety of factors. One of the questions that we get asked all the time is, can we have a meeting at a board member's house? The answer to that is, technically, yes. The real question is that a good idea? Meaning, is the public going to feel like that is open to them as the public to come to their house? Personally, I don't think the answer to that is always going to be yes. It's a little bit different going to somebody's house than having a meeting like here. This is clearly open to the public. The same question comes up with regard to churches. There are members of the public that just do not feel comfortable walking into a church. There are members of different faiths that don't feel comfortable walking into churches of different faiths. And so those are all things to think about when you're planning on where to hold the meeting. You can conduct meetings using telecommunication devices. The requirement on telecommunications devices is that you have to ensure you've got either an executive director or a board member in the room with whatever the device is. Meaning you can't have a meeting where folks walk into an empty room with a black speaker in the middle of the floor. It's not a science fiction movie.
Although I've been in a few meetings that felt like that.
The other question, and again, this is kind of how the law is evolving with technology. We get asked now a lot of questions about Skyping. Can you have a Skype meeting? The same rule applies. Yes, you can have it, but you have to make sure you've got a room where folks can come in and observe the meeting. This is a good example because you could broadcast the whole Skype meeting up there. Everybody can see what's going on, and you can observe it. You also cannot, since we're on the technology subject, you can't text among yourselves during the meeting instead of discussing, because that again evades the very purpose of the meeting. The other thing is that if somebody does think that you're texting, those texts are probably all public records. And so that's something else to keep in mind if that goes on. The other thing that I will caution folks on is I'm a firm believer in government as a customer service business, meaning government is there, the customers are the constituents, government serves the constituents. One of the things to always think about within your meetings is how the public perceives your conduct. And so, for example, you see the Attorney General and Betsy sitting up here, and you can see their faces. But imagine if they're sitting up there behind a wall of laptop screens, or iPad screens, or Surface screens. And so essentially you have a meeting with the city council's foreheads and never make eye contact. Again, that's not technically an open meeting violation, but is that fostering confidence within the interaction that you're having with that governmental entity? Especially when you consider the fact that on some of these issues, these are things that people have been waiting a long time to come down and address with the city council or the county commission. And by the time they get there, all they see are the wall of screens. Just something to think about with regard to that.